Good afternoon, students. In our last class, I was talk about disciplinary action, that is introduction of disciplinary action. There was another topic on which a comparison of lockout versus layoff will be discussed. All these are a part of industrial relation. So industrial relation is a very vast and conceptual knowledge, and you have to know all the guidelines, all the highlighted portion which is very relevant to the industrial relation. So in this class, we will talk on detail about the disciplinary action. That is, what are the guidelines that should taken by a businessman or the employees whenever they enter or whenever they deal in the corporate world. So in this class, you will know about the disciplinary action against employees if they have performed any misconduct. You will learn about guidelines of disciplinary action, procedure for disciplinary action, penalties and punishment, process for disciplinary action, punishment in detail, suspension for disciplinary action, dismissal and discharge of an employee. So, the first topic will be the guidelines of a disciplinary action. All these are list of guidelines which you should to know about when you talk about or when you deal with the industrial or a corporate world. So the first topic will be the first point of related to disciplinary action is location of responsibility. The responsibility for maintaining discipline should be entrusted to a responsible person, that is a line executive, though it is the personnel officer who should be entrusted with the responsibility of offering advice and assistance. The line executive should issue only verbal and written warning in serious cases which warrant discharge or suspension. The industrial relation officer should be consulted. Number 2 will be the proper formulation and communication rules. Since employees are expected to conform to rule and regulations and behave in a responsible manner, it is essential that these rules and regulations are properly and carefully formulated and communicated to them. It would be preferable if a copy of this regulation together with any explanation thereof is included in their handbook. At any rate, they should be put up on notice board and bulletin board. While finalize the rules, everyone should be given the opportunity to express freely his views thereon. The third point which you consider when you talk about the guidelines are rules and regulations should be reasonable. Plant condition and management climate should be such as would be conducive to the observations of rules and regulation. The workload should be such as is practicable in normal working condition for an average employee, while penalizing him for not producing an item in accordance with the standard laid down for it. The supervisor should first determine whether such a standard was attainable and whether the employees were capable of producing it in accordance with the standard laid down for it. Rules should continually be re-evaluated to ascertain whether they are applicable to changing organization condition. Employees tend to lose respect for rules that either seems illogical and out of date or are not enforced. Further, rules should always be enforced equitably, promptly and consistently, or they will lose their effectiveness. Equal treatment. All defaulters should be treated alike depending on the nature of their offense. Identical punishment should be awarded for identical offenses, irrespective of the position or seniority of the employee. It is a bad practice to punish one man for an offense and let off another for no other reason than he is a favorable of the management. Experience shown that no one likes to be treated in a manner which he thinks is not just. That is why overall severe penalties, inconsistency, applied rules, favorism and other disciplinary action breed dissatisfaction. Thereafter, the supervisor should make sure that rules and penalties are applied equitably, the same to everyone. Disciplinary action should be taken in private. This is essential because the main objective of a disciplinary action is to ensure that a wrong behavior is corrected and not that the wrongdoer do be or should be punished or held up to ridiculous. If a disciplinary action is taken in the presence of other employees, it may offend the sense of dignity of the employees and impair his social standing with his colleagues. Such an action may rouse resentment in the employee and in his fellow worker and make for a disturbed climate in the organization. The subordinate's dignity should not be robbed. For the diesel suggests that following hints should be kept in mind. The subordinate should be disciplined in private. Avoid entrapment. Don't deliberately rig a situation that causes him to require disciplining. Don't use an otherwise innocent and non-time or one-time offender as an example. Don't suddenly tighten the enforcement where enforcement has previously been lax. Don't attack his personal worth for specific offense. Attack the act, not the man, and don't base comment about him overall worth on one or two specific offenses. Don't apply penalties inconsistently. Importance of promptness in taking disciplinary action. Justice delayed in justice denied. If the penalty is imposed long after a violation of rules has been committed, it loses its positive and corrective influence and may even induce resentment, which may not have developed if the penalty had been imposed in time. Care should therefore be exercised to ensure that a penalty is imposed soon after an infringement of a rule has occurred and that the punishment is not unfair. If decision has been taken for termination of an employee, it should be implemented soon. Often, even if some notice is mandatory, immediate dismissal with the salary for the requisite notice period paid in advance is preferable to retaining the employee for that period because such an employee would not only be productive during these days but he also would sow the seeds of discontent among other employees. Innocence in presume. An individual is presumed to be innocent until he is proven to be guilty. The burden of proof is on the employer and not on the employee. It is for the management to prove beyond a reasonable doubt that a violation or an offense has been committed before any punishment is awarded. The kind of proof that would be needed for his purpose would depend on the gravity of the offense that has been committed. Get the fact. Before taking any disciplinary action, it should be made sure to get and keep adequate record of offense and warning. If it is always better to let the subordinate fully explain what happened, why it is happened. It may then be discovered that they were mitigating circumstances, or that he was not aware of the rules, or that the person has conflicting order or even permission to break the rule for same reason. Getting facts is a good management practice, especially when defending the decision to superior, union arbitrator and other. Action should be taken in cool atmosphere. The action should be taken not when one is anger, but when the anger has cooled off a bit, so that rational and sensible judgments could be taken. Further, the subordinate should be clearly told as to what rules or regulation has broken and how it was broken. Specific detail need to be given, not just the generalities or generalities discussed. Natural justice. A punishing action must satisfy the condition of natural justice. The management must act without bias and without victimism. It should always indicate that its disciplinary action against an employee is based on justice and fair play. The punishment should be commensurate with the gravity of the offense, and it should be corrective or reformative rather than retributive. The employee should be taught to behave better. He should be rehabilitated and not injured. After a disciplinary action has been taken, the supervisor should treat his subordinate in a normal manner. The employee has paid the penalty for his violation of a rule. He should therefore be treated as he would have been had there been no violation and no punishment. The attitude of the supervisor should be forgive and forget. Once the subordinate has been disciplined, the supervisor should assume that he is starting then with a clean state. He should not harbor a grudge and that make others assume that he is prone to engaging in vengeance. Don't back down when you are right. When the supervisor knows that he is right, that the rule was broken, that adequate warning is given, that the penalty is not too severe, he should not back down or compromise on penalty, especially once the decision is announced. In most cases, being soft is not viewed as a virtue. Instead, employees either assume that the rules itself is frivolous or that the rules and penalties are being applied inconsistently. In either cases, backing down is not advisable. Negative motivation should be handled in positive manner. The philosophy behind administrating disciplinary action is that a negative motivation should be handled in a positive manner. That is, it should be brought home to the employee that a negative approach does not pay. Positive-oriented managers generally feel that discipline should not punish but instead be corrective and constructive. As far as possible, disciplinary action should deal with specific rule infraction rather than with the employee in general. The saying, "let the punishment fit the crime," is appropriate when disciplinary action is taken. Who should discipline? Usually, the immediate supervisor of the worker is an appropriate authority to provide corrective comments and to suggest future course of action. Since he is responsible for the action of his subordinates, he is better knowledgeable concerning the level of performance required and the individual worker's action in meeting specified standard. When action appropriate? Some managers operate on the assumption that a worker should be corrected at the first hint of mistake, while the other Managers prefer to postpone action until a deliberate pattern of error can be identified. The most appropriate time for disciplining to occur is after the fact indicate that the individual in question has performed unsatisfactorily and has failed to take initiative in corrective his own behavior. Disciplinary action procedure. That means what are the procedure you have to consider when you made a disciplinary action. Although there is no specific procedure to be followed, the following steps should be taken into the consideration. Disciplinary actions, so first procedure would be accurate statement of the problem. The first step is to ascertain the problem by seeking answer to the following question. Does this case call for a disciplinary action? What exactly is the nature of the violation or offense? Under what condition did it occur? Which individual or individuals were involved in it? When or how often did the violation occur? In other words, an execution must first find out that a violation has occurred and that is entirely the fault or at least particularly the fault of one or more subordinate. The next step is to determine and state the nature of the alleged violation of a rule, a regulation, a policy to determine whether a request or order has been ignored or broken, and assesses the seriousness of the specific offences which has been committed. It is also necessary to know exactly who and what was involved in the violation, whether a particular individual or a group. Finally, it is desirable to know when and how often the violation occurred. The second step will be the collecting facts bearing on the cases. Before any action is taken in a case, it is essential to gather all the facts about it. A thorough examination of the case should be made within the stipulated time limit. The fact gathered should be such as can be produced before a highly authority if and when needed. The third procedure will be selection of tentative penalties. The kind of penalty to be imposed for an offence should be determined. The kind of penalty to be imposed for an offence should be determined before. Should it be a simple replenishment, a financial or non-financial penalty, or should it be demotion, temporary layoff, or outrage of discharge? All facts must be considered in that case. The next procedure will be choice of penalty. When a decision has been taken to impose a penalty, the punishment to be awarded should be such as would prevent a recurrence of the offence. If the punishment is lighter than it should be, it may encourage the violation of the same rule or another. If it is greater than it should be, it may lead to a grievance. The next procedure, application of the penalty. The application of the penalty involves a positive and assured attitude on the part of the management. If the disciplinary action is a simple replenishment, the executive should calmly and quickly dispose of the matter. But when severe action is called for, a forthright, serious and determined attitude is highly desirable. The last step will be the follow-up on disciplinary action. The ultimate purpose of a disciplinary action is to maintain discipline, to ensure productivity and avoid a repetition of the offence. A disciplinary action should therefore be evaluated in terms of its effectiveness after it has been taken. In other words, there should be a more careful supervision of the person against whom a disciplinary action has been taken. So, penalties and punishment. It is the one part of disciplinary action, or it is the effect of disciplinary action. As a result of custom and well-established practices, Industrial penalties have become a fairly standardized. They vary from mild to harsh, from oral replenishment, written replenishment, loss of privilege and fines to temporary suspension, demotion or discharge. Ordinarily, there are different penalties for the same offence when it is committed once, or the second time, or the third time. Minor offences generally call for the application of a progressive penalty system. For an average person, an oral replenishment is enough to prevent repetition of the same offence. A written replenishment is administered when an offence is committed the second time or when it is a somewhat serious nature. The penalties of the loss of privilege, withholding of increment, restriction on free movement in the place of work, withholding of the right to choose a machine or equipment with which or on which he should prefer to work, posting on an uncongenial job may be imposed for such offences as tardiness, disobedience of the order of the supervisor or of safety rules, or being unnecessarily noisy while at work. For more serious offence, for example, gross negligibility of duty or gross negligence of the duty, repeated misbehavior or infliction of an injury on another employee, or fraud, the penalty may be temporarily layoff from 1 to 7 days without pay. Demotion as a penalty is rarely used, but whenever this penalty is imposed, it is usually by top-line executives. Discharge is, of course, the severest penalty that can be imposed upon an employee and is awarded for such serious offences as fraud of a serious nature, sabotage or working against the interest of the company. Even so, this weapon is used only at least as a reason, a sound reason. A disciplinary action thus takes a variety form, a simple oral replenishment to discharge. The offences for which an employee may be discharged are listed now. The first will be the types of action or the types of offence under which action most frequently leading to discharge after a first offence are theft, falsifying application for employment, possession of narcotics, with willful damage to company's property, possessions of firearms or other weapon, falsifying record of work, fighting, off-the-job criminal activities, failure to report injuries, unauthorized strike, supervise or subordinates activity, drunk while at work, and punching another employee's time card. All these are small offences, but the action will be taken when it is created for the first time. Action most frequently leading to discharge after second offence: sleeping on the job, use of abusive or threatening language to a supervisor, insubordination and gambling. Action most frequently leading to discharge after third offence is horseplay, unauthorized solitary, leaving work without permission, failure to use safely service, smoking in unauthorized place, and shutdown on production. Action most frequently leading to discharge after a fourth offence are carelessness, chronic absenteeism, unexcused absence, and unexcused or excessive lateness. Some executives have developed other way of punishing an employee without actually discharging him, as the flow of work is so altered as to pass around a particular employee so that he may have nothing to do, so that he may be bored and get fed up and so submit his resignation. The post may be abolished, and after the concerned person has left the organization, the duties may be reassembled and a new employee may be hired to do that job. The resignation of the employee may be secured by bringing some pressure to bear upon him or by threatening him with other and more serious consequences. The employees may be transferred with some other department. In other words, the whole hot potato may be pitched to someone else. In higher position, the undesirable person may be pushed off, that is, he may be promoted out of turn, may be made a consultant who is never consulted. In this concern, it may be borne in mind that it may be enough for some employees to get a severe chewing out to ensure that they do not become guilty of any other violation in future. For others, even a casual reference to their deficiency may be adequate enough to ensure that they fall in line. For this class, we have concluded here, but the topic is not completed here. Therefore, the rest part, that is the process and other disciplinary action, will be discussed in your next class. So for today's concern, I am ending my class here or my lecture here. If you have any doubt, you can ask me in the class. Thank you.